Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. At this point in time, there are two known civil lawsuits concerning the catastrophic events that occurred at 1122 King Road on November 13th, 2022. The second action was just filed in a Washington state court, and this is the matter styled as Gonzalez et al. Versus Washington State University, a public university. The first known civil action for money damages was Schofield versus Guillard. We have been following this case, reporting on it. Schofield versus Guillard deals with two counts, state counts, common law claims for defamation brought by Rebecca Schofield, a University of Idaho professor, against Ashley Guillard, who is described as a TikToker, online personality, psychic in the complaint. That case was filed in federal court December 21st, 2022. It is getting ready to go to trial in federal court, District Court of Idaho, in February. The question's arisen: why is the second lawsuit for damages, civil action, filed in state court, not federal court, considering the fact that one of the claims, the first claim, count one, is for violations of Title IX of the Education Amendments of 1972. And then in parentheses, 20 U.S.C., and then that squiggly mark there, 1681. This means 20 United States Code, Section 1681. That's Title IX. Plaintiffs are alleging in paragraph 370, they seek to hold WSU liable for its own decisions and actions to remain idle in the face of known, extreme, and repeated instances of wrongdoing by Mr. Kohberger occurring in its educational program through the entirety of the 2022 fall semester, and that ultimately what they're alleging led to the harms that were inflicted upon their children on November 13th, 2022. If you read the complaint 93 and thereafter for the next several pages, it will give you details regarding what the plaintiffs are alleging. And it must be said, these are allegations. These are not proven facts. It will be the plaintiff's obligation to prove every element of what's required in Title IX and every other count that they raise, including, for example, negligence, in order to prevail. Washington State University will have an opportunity to be heard after they're served with process, summons, and a copy of the complaint to then file what's typically done as a responsive pleading and answer and affirmative defenses, or a responsive motion, such as a motion to dismiss, if they feel that what is stated within this complaint does not comport with requirements of law to raise these claims. So the question is, there's a federal count here. It is, in fact, count one. Why wasn't this lawsuit filed in federal court like Schofield versus Guillard was, given that Schofield versus Guillard is all about state claims, where this lawsuit, count one, is a federal statute alleging violations of Title IX? There is, of course, no way to know what counsel advised the plaintiffs where to file this lawsuit, whether state or federal. An answer might be in the fact that there is not diversity of citizenship, which is a requirement to file state claims such as negligence, which is cited herein amongst other state claims. In order to prosecute a lawsuit in federal court, there needs to be complete diversity of citizenship. In other words, every defendant and every plaintiff is of a different state. Schofield versus Guillard, the complaint says, Schofield is a citizen of Idaho. Guillard is a citizen of Texas. That was stated within the complaint in order to raise jurisdiction in federal court. Here, although there is a federal statute, there's not diversity of citizenship on all sides. One of the plaintiffs is a citizen of Washington, as this complaint states. The defendant, there's only one, operates in Washington. Until next time, my name's Kathy. Thank you for joining us here today.